in disability insurance, obviously whatever's in the contract becomes critical. And the contract, as I understand it, Alan, describes what my occupation is and what it's covering me if I'm disabled. But there are some catches there that all have to do with definition. Tell us a little bit about that, if you would.
Yeah, what comes to mind, I was an expert witness on a case in New Jersey. It was a thoracic surgeon in South Jersey, and he was disabled, and he put his claim in, and the carrier reviewed the claim and denied it. And this gentleman happened to be best friends with my in-laws, and again, he's not my client, and I was happy to get involved with the case, etc., and with the attorney. And the bottom line is, where he thought he had a specialty definition, which simply means if you can't perform the substantial material duties of your occupation, even though you can do anything else out there based on your education and training, etc., you're going to get paid. Well, his definition was, it was an ONOC definition, but it had the caveat in there, if you can do any other gainful employment based on your education and training, you're not getting paid. So the carrier deemed that, yeah, you can't do surgery, Dr. So-and-so, but you can teach, you can consult, you can still run the practice as a consultant, etc., to your patients. So it went through the courts, and the judge ruled in favor of the insurance company. And
because the provision in the policy read that they didn't have to cover it, and he hadn't been aware of that at the time that he bought the policy.
The agent at the time that sold him the policy out of Philadelphia, Pennsylvania, was in Forbes magazine, noted as one of the top agents in the country, whom I knew well, and it just goes to show success doesn't always mean you're getting the best advice.
So the moral of the story then, Alan?
Know your contracts and don't trust your agent.
Be sure you understand what's in it.
Absolutely.